Good evening and welcome to 42BR Barristers Introduction to Disability Discrimination Law for Housing Lawyers. My name is Rebecca Thomas. I'm the head of the employment team at 42 and this is my colleague Stefan.
Yes, and I am a housing and employment law dual specialist. I've been at 42BR for 10 years now, and as I say, my areas have become employment and housing. So to give an overview of this topic from the perspective of someone who practices in housing and employment law, disability discrimination is an area of growing significance in housing law and practice, and particularly with mental health conditions come up more and more frequently. And in my practice, I've seen, and I'm no doubt those watching have observed this too, it comes into play in a number of housing areas, one being antisocial behaviour cases, both injunction proceedings and subsequent committals, as well as possession claims brought on that ground. It comes up in rent possession claims, where there is said to be a disability that might have caused the tenant to get into rent arrears. And it also comes into play quite frequently with homelessness cases. So, for example, looking at suitability of homelessness accommodations and review challenges. Now, most often we see the Equality Act and disability discrimination raised as a defence by the tenant. So where the landlord's brought a claim for possession or perhaps an injunction application, and the tenant, often with the benefit of legal advice, because it's a complex area, raises a defence under the Equality Act, potentially with a counterclaim as well, where they're seeking damages against the landlord for disability discrimination. But in the housing field, it can also be used by tenants to make a standalone claim, and this is something that I've worked on more than once. So tenants can bring their own claims, usually in the county court, for disability discrimination against their landlord. And those obligations apply equally to private landlords as they do to social landlords. So with that overview in mind, Rebecca, what are we going to cover today?
So the purpose of today is to start at the very beginning and look at the legal test for disability itself. It's not a straightforward question, and it's extremely important that it's dealt with properly in any disability case. So that's what we're going to go through in some detail today. And then the next session is going to be on the 13th of December at 5 o'clock. That's going to be an in-person session where we hope you'll join us for some mulled wine and a mince pie. And then we'll be looking at how disability can be proved in practice once we've established what that test is.
Thanks, Rebecca. So before we go into looking at the law on disability, as a preliminary question, who actually decides whether a person is or isn't disabled under the Equality Act?
Yes, so this often causes confusion. The question about whether someone is disabled under the Equality Act is a legal question that will be determined by the court. And it's a common misapprehension that either the meaning of disability is the same as for other areas, for example, whether you get a blue badge or not, or sometimes it's thought that medical practitioners can decide. In fact, just today, I was doing a case involving autism, where the practitioner had stated that it was a disability under the Act, and the individual concerned thought that that was the end of the matter, and was quite surprised when the judge told him that that wasn't the case, and it was for the tribunal in that case to decide.
Interesting. So it's always decided where it's executed by the court or the tribunal,
yes,
as applicable. So when the court's making up decisions, and when practitioners, housing practitioners, are looking at whether someone's disabled or not, what are the materials, the source materials that they need to work with?
So the most important material, of course, is the Equality Act itself, which sets out the definition of disability, and that is the key discrimination statute. So we used to have different statutes, for example, the Disability Discrimination Act, but now it's all combined since 2010 in the Equality Act, and that's our starting point for the test of disability. Now, the Equality Act, most people know it covers employment, but it does cover other areas, including housing and also education, for example. Now, that Act is supplemented firstly by regulations which provide specific pieces of information in relation to that definition. But then there is also government guidance which has been produced, and that was produced around the same time as the Act came out. It hasn't really been updated since, but it is a key document that is used. And then, of course, there are the cases that have interpreted the statute. Now, it's fair to say a lot of those cases are employment cases, but housing has an important part to play. And in fact, it was the House of Lords decision in the case of Malcolm and Lewisham, which in fact led to a change in the disability legislation when it came into the Equality Act. So not to be ignored.
Okay, thanks, Rebecca. So we've got the Equality Act itself, and you mentioned there's the regulations and the guidance that supplement it. So starting with what the Equality Act says, and it's section 6, what are the 3 elements of the test for disability?
Yes, so there are 3 parts to the test, and the first element that you've got to look at is whether the individual has an impairment, and that can be a physical or a mental impairment.
Okay, so we've got to establish a physical or mental impairment. Does there need to be a diagnosis in order to show that? Do we need a doctor to say, yes, this person has this condition? No, we don't have to have a formally diagnosed condition, and in fact, quite often we will look at the effect of what's happening to someone to see if there's something there. Now, this is one of the things that we are helped by the guidance, and that tells us that impairment has its ordinary meaning, and there's no need to establish a cause for that impairment. Okay, so we'll go on to the second element at the moment, which is the substantial adverse effect. But it sounds like sometimes potentially, even if you don't have a diagnosis, could you look at whether somebody suffers from an adverse effect on their daily life and work backwards from that to infer that there's an impairment?
Yes.
Okay, so let's look at that second element then in a bit more detail.
Yes.
It's a substantial adverse effect on the person's ability to carry out normal day-to-day activities. So let's break that down first. Rebecca, can you help us? What are normal day-to-day activities?
Yes, again, that's something that's not actually defined in the Act itself, but we can look to the guidance to give us some help on that. And the guidance tells us it's things that people do on a regular or daily basis. And if we look at the guidance, it will give examples of things that people do every day. And the guidance does distinguish between things that people do regularly and things that might be very highly specialised activities, and they would not normally count as normal day-to-day activities for the purpose of the Act.
Yes, I saw something in the guidance, I think, about playing the piano to a very high standard.
Yes.
Which playing to the standard of a concert pianist might not be a normal day-to-day activity.
Yes.
But being able to sit at a stool to play the piano for a period, that might be.
Yes, and all those
activity.
things like shopping or preparing food or things like that
Yeah.
people do on a regular basis.
So does a person have to show that they can't do a particular activity at all?
No, they only have to show a substantial adverse effect on their ability to do it. And you're probably going to ask me what substantial means in this
That's
case.
my next question.
So the Act does help us when it comes to the question of substantial. And we find that tucked away at the end of the Equality Act in section 212, which is a very general definition section covering lots of different things in the Act. But that tells us that substantial just means more than minor or trivial. People are sometimes a bit surprised when they hear that, because I don't know about you, when I think of substantial, I think of perhaps quite a high bar, but in reality, it's not a very high bar in this test.
So if you're trying to show a substantial, so a more than minor or trivial impact, if somebody can do something but it's more difficult or it takes longer, are there ways of showing it that way?
Yes, that's a good example. Things like sometimes having difficulty sleeping, for example, it is another one where you might be then tired or lacking motivation. So it's that sort of thing.
Okay, and you can probably think of cases maybe where somebody could physically do something, but they've been advised by their doctor not to do it because it puts them at increased risk, and that might be, I suppose, a substantial adverse effect as well.
Yes, yeah. Yes. And the other thing to bear in mind is it'll be the normal day-to-day activities for the individual. So, for example, if you might think that getting up is a morning activity, but if you're a night worker, it might not be. So you do have to look at the particular circumstances in the individual case.
So for that person, it would be getting up at the start of their night shift.
Yes,
is the normal activity. Yeah. Okay, and does the guidance give us any examples or lists of what might or might not be a substantial adverse effect?
Yes, and this is another place where you will go to the guidance, because it gives you some really good practical examples. And so, for example, one example they would give is the time taken to carry out an activity. And they give the example in that case of a 10-year-old child with cerebral palsy, whose effects include muscle stiffness, poor balance, and uncoordinated movements. And they said the child is still able to do most things for himself, but he gets tired very easily, and it's harder for him to accomplish tasks like eating and drinking, washing and getting dressed. He has the ability to carry out everyday activities, but everything takes much longer. And they say that is an example of what would amount to a substantial adverse effect.
Okay, that's interesting. Thank you. So a lot of people with certain conditions might use coping mechanisms to make it easier for themselves, or they might avoid certain things that trigger their condition. So an example I can think of is somebody with anxiety disorder. They might avoid situations that could trigger a panic attack.
Yes.
Now, if they can use those avoiding or coping mechanisms, does that mean that they're not disabled under this definition?
Not necessarily. It's a question of what is sort of reasonable for them to do. So I think the guidance gives the example, if someone had an extreme phobia of heights, for example, it would be reasonable for them not to go up the Eiffel Tower, but not reasonable for them to avoid all multi-storey buildings. So that would be a substantial effect.
So it sounds like there's a bit of common sense to be used here.
Yes.
Yeah. Yeah. Okay. And sort of related to that, what if they're taking medication or having some other kind of medical treatment that lessens the impact of the condition on their daily life?
That's a very important point, because what we are told about that is that when you are considering whether the impairment has that substantial adverse effect, you have to look at what we call the deduced effect. So you have to look at what the position would be if they weren't taking that medication. And the classic one, of course, is someone with depression who is on antidepressants, and the court would be expected to look at the position that would be if they weren't on those antidepressants.
Okay. So it sounds like that might be a sort of hypothetical assessment of how they would be if they weren't taking, let's say, as in your example, they're taking medication and they're having cognitive behavioural therapy.
Yes.
The court will look at hypothetically what would they be like if they weren't having that treatment. So how can we know what they would be like? How can you prove that?
So with medication, it can be quite difficult, and you may have to consider whether there is some expert evidence about that fact. So the opinion of a medical practitioner. You could, if somebody has started the medication, you could compare how they are on the medication rather than when they were not on it. For some, it will be much more straightforward. If you're on some kind of life-saving medication, or let's say insulin for diabetes, then it can be fairly easy to work out. But it's those more nuanced things like depression, where you may have been on medication for a very long time, and it may not be quite clear what the position would be if you came off. I think that's something that is going to be looked at in more detail in the next session, how we prove these matters.
Yes, that's our in-person session on the 13th. And just on that point, I'm short-sighted, and I wouldn't be allowed legally to drive unless I had my glasses or contact lenses in. Does that allow me to be counted as disabled?
No, is the short answer. Unless you are, I think, actually certified as blind, wearing corrective lenses is not considered as a disability.
So that's the exception, is it, to this general point about deduced effects? Okay. So we've looked at the first and second element. So there's physical and mental impairment, and then there's a substantial adverse effect on the ability to do normal day-to-day activities. And then the third part of this, I think, is it has to be long-term.
Yes.
So what does that mean, Rebecca?
Again, not a straightforward question. This we look to the schedule to the Equality Act, and that helps us with that. And I'm just going to pull that up, if you don't mind, because it's an important one that you get right. So this is my Bible, and you'll see employment lawyers carting these around. There we go. So we find this in Schedule 1 to the Equality Act, and it's paragraph 2. I'm going to read it first, and then we'll talk about what it actually means. So that tells us the effect of an impairment is long-term if it has lasted for at least 12 months, is likely to last for at least 12 months, or it is likely to last for the rest of the life of the person affected. Those are the three ways we can look at the question of long term. The first one is very straightforward, and it's important to bear in mind that what we're looking at in the long term is that substantial adverse effects, not the impairment itself.
Okay, so it's not necessarily the diagnosis or the condition or the impairment being 12 months or more, it's the effect that it causes, the substantial adverse effect it causes lasting that long. Okay.
And that is a common misconception. People think, oh, well, I've had this condition for 12 months and therefore that's it. And you can have it, for example, if someone has had an injury, let's say a broken leg, and it's taken some time to heal. At the outset, obviously a substantial adverse effect. At the end of 12 months, they may be having some effect, but not a substantial one. So that's what we have to look at.
Okay, so they have to show this usually 12-month or more period, or that it's likely to last more than 12 months.
Yes.
What does likely mean in this context? Because normally as lawyers, we say likely means on the balance of probability, so more than 50% likely.
Yes, it's a bit less technical than that. Okay. What they say about likely is could well happen. And you can imagine that gives the courts quite a lot of leeway at times when they are looking at a condition. It may be by the time this comes to be decided by a court that it has lasted 12 months, but they will be looking at the time the alleged discrimination occurred.
I see.
And whether they were disabled then. And
so if we take an example that the tenant's alleging that the landlord's decision to serve a notice seeking possession on them was an act of disability discrimination. So we're looking at whether they were disabled at the point when the notice was served.
Yes.
So let's say, I don't know, they had been suffering with a severe leg injury for 8 months up to that point.
Yes.
So would we then need to work out at that point, was it likely to last another 4 months to make it 12 months?
Yes.
Okay. I see it. And you base that on what you know, what was known at the time, do you?
Yes, and as I'm sure you will touch on in later sessions, knowledge of disability it is often an important question when you're deciding this matter.
Okay.
We also need to think about conditions that may not be consistently substantial, but are over that 12-month period.
Yes, I was about to ask about that because a lot of conditions fluctuate like this, so people can have good or bad periods.
Yes.
Particularly with mental health conditions. With depression, people may have good weeks and bad weeks, or say bipolar, people have manic and depressive periods, and they may have more normal periods in between. If somebody has a 1-month period when they're okay, does that break up the 12 months and means that they have to sort of reset the clock again, as it were, to show the long term?
No, and it can be a bit tricky to work out sometimes. And again, I'm going to keep saying this, but when we look at the guidance, it gives us a very clear steer on this in its examples. And I'm going to look at those now, because it gives 2 examples, and they're both to do with mental impairments, which is often where this question arises. So the first example they give, and this is where you have to concentrate and do some maths, they refer to a young man with bipolar affective disorder. So they describe that as a recurring form of depression. They say in this example, the first episode occurred in months 1 and 2 of a 13-month period. And then they say the second episode took place in month 13. And they say in those circumstances, that will satisfy the requirements of the definition, because the adverse effects have recurred beyond 12 months after the first occurrence. And therefore, they're treated for the purposes of the Act of having continued for the whole period. So that's a period of 13 months in total. They then contrast that with a woman who has 2 discrete episodes of depression within a 10-month period. And they give the example that in month 1, she loses her job and she has a period of depression for 6 weeks. And in month 9, she experiences a bereavement and has a further episode of depression lasting 8 weeks. Now, assuming that they were both substantial adverse effects on her day-to-day activities, she wouldn't satisfy at this point the definition, because we were only talking about a 10-month period. Obviously, then if at a later stage she had another period, that she may well then fall within that definition.
But could she say in that example that if she has an underlying diagnosis of depression, it means that after the 10-month point, the 10-month episode, she's likely to have another episode again in future, because that's the nature of her condition, and therefore it's long term?
That could be evidentially, but I think they've chosen the example they have quite specifically in that they're very discrete and reaction to life experiences, and I suspect that's why they've chosen the examples they have to try and not fall down that rabbit hole. But yes, that's right.
Okay, so we've looked at these conditions that fluctuate over time and how people can be protected under the Equality Act with those. What if someone has a progressive condition? So some conditions, they're diagnosed and initially there might not be much of an effect on their daily lives, but they know that it's going to get worse over time. How does the Act protect them?
Yes, so this is another thing that is expressly dealt with in the Act, and it's another thing that we find in the schedule to the Act. And the short answer, if it's likely to cause a substantial adverse effect in the future, it's deemed effectively to have that effect now.
Okay, so that might protect, I think, somebody with Parkinson's disease, for example. If they might have a diagnosis and it might not be affecting them substantially now, but if it's likely to in the future, then they'll be deemed to have that effect already.
Yeah, and there are a number of conditions, motor neuron disease, for example, or something like that, which are known to be progressive in that way.
Okay, and let's look at sort of an opposite scenario. Sometimes people do recover completely from whatever the condition is. So they're no longer disabled. So they're no longer having a substantial adverse effect from whatever the condition is or was.
Yes.
And there's no likelihood of it recurring in the future.
Yes.
They've stopped taking any medication that they were on. Do they still have any protection at that point?
Yes. So if you have the protection if you have a disability or had a disability in the past. And so once you have satisfied that test, then you retain the protection. The question will then become whether you've been discriminated against because of a past disability. But the actual fact of whether you qualify under the Act is clear, and we find that in section 6(4) of the Act. Now, one thing that was interesting was under the Disability Discrimination Act, so the Equality Act's predecessor on disability, you had to show that it had lasted 12 months, your past disability. Right. That requirement wasn't imported into the Equality Act. So some people questioned whether it would have been enough to show that it was the past disability was likely to have lasted 12 months, even if it didn't actually. But the general view is that that probably isn't right, and you would have to show that it had lasted 12 months.
Yeah, that seems more common sense, I suppose. Yeah. Okay, so we've seen that with most conditions, it's not enough to just say you have a condition or a diagnosis or impairment. You've got to show this long-term and substantial adverse effect on your day-to-day activities. But are there any conditions that are automatically disabilities as soon as you have them?
Yes, and the main one which comes up most commonly is cancer.
Okay.
And once you are diagnosed with cancer, then that is an automatic disability. And we also find in the Equality Act, in the regulations, that HIV and I think it's multiple sclerosis, isn't
yes.
it? Are the deemed disabilities.
Yeah, and I think we'll have a full list of those in the handout.
Yes.
At the end for people to be aware of. Okay, so when we're looking at how this works in practice for housing practitioners and lawyers, it seems unless somebody has one of these specific deemed disabilities that as I said will be in the handout, they'll have to go through those 3 questions we've talked about and work out whether the definition's met.
Yeah, yeah.
And I suppose generally the advice for landlords would be, if you're in doubt, assume that they are disabled and sort of act accordingly. And no doubt you give that advice to employers as well in your field.
We do, and yeah. the appellate courts have noted that quite often people work on that precautionary basis, and you won't be criticised for doing so, and it won't be seen as a concession on what is essentially a legal question.
Okay, and as a sort of opposite point to this, are there any conditions or effects of conditions which can't be a disability?
Yes, and there are a number, and they relate in relation to what we might term antisocial type behaviour, and so they include things like a tendency to set fires, a tendency to steal, a tendency to physical and sexual abuse of other persons. Exhibitionism and voyeurism are conditions that are not to be treated as disabilities. Other things include
what about addiction?
Addiction to alcohol and drugs, and so.
Okay, so these we do see quite frequently in a housing context. Yes. So let's take one of those as a tendency to set fires. Let's say you have a tenant who sets fire to their neighbour's fence, and the possession claim is brought against them for antisocial behaviour. I can see that they wouldn't be able to argue that that behaviour was as a result of any disability, any mental health condition, for example. But we know as well that a lot of mental illnesses have lots of effects.
Yes.
And they might have one of these excluded effects, but have other effects that aren't excluded.
Yes.
So how do you deal with it? Can you say that if someone has, say, a personality disorder, and one of the expressions of that is they set fires, can you just say, well, that's not a disability in any respect, and we can ignore it?
No.
Okay.
It's a short answer. You're still protected for those substantial adverse effects, which are not one of those prohibited factors.
I guess then if the person has that tendency that's excluded, but because of their mental illness, they also can't concentrate and do something like, say, fill out a benefits application, and then they get into rent arrears, and the rent arrears claim is brought against them, then they could still argue that in that respect it's a disability if they can show the substantial adverse effect.
Yes, that's right. And so it would be the particular behaviours that wouldn't get the protection, and you can see there are probably public policy reasons why those matters are excluded.
Yeah. And similar to that, what if you have someone who has an addiction, let's say alcohol addiction, and that goes on to cause them some physical health problem, like they develop liver disease, and the liver disease has its own effects on their health and daily life? Could they rely on that even though it's caused by alcoholism?
Yes, because it doesn't require you to look at the source cause of the impairment, as long as the impairment itself is not excluded. And so a classic is an alcoholic who then suffers significant physical health issues, such as problems with liver disease, for example. That they would be covered for that. They wouldn't be covered if they crash their car drunk driving.
Okay, so we have looked a bit at what conditions are excluded from the definition of a disability. Are there any groups of people who are excluded? And what about young children, for example?
So nobody is excluded from the Equality Act, and it can cover children. You may be sitting there thinking, well, children won't be tenants of a property, but as I expect we'll look at it in a later session, you can also have discrimination by association. So it may be relevant to look at all the members of the household, and children is an interesting one. Now, obviously, it can be much harder to look at that question of that substantial adverse effect on a child. And so what the regulations provide for is that if the impairment is in a child under 6 years old, if it's the case that the adverse effect if the effect would normally be substantial on a person aged 6 years or older, then it's treated as being substantial adverse for an under 6-year-old. So you don't have to prove it directly in respect to an under 6-year-old in the same way.
I can imagine how that would be harder if you had to do it. So the Act allows a way around that.
Yes. If it would normally have that effect, then it will be treated as being safe for that individual. And
I think you're right, Rebecca, that children may well be relevant in housing cases, because the Act protects not just tenants but occupiers as well.
Yeah.
Obviously, that could be children in inappropriate cases. Okay, so we've gone through those 3 parts of the test for disability in the Equality Act and what each of those means. But we've looked at the schedule and the guidance as well, and these excluded and as well as automatic conditions. As Rebecca mentioned, the handout recapping these points and with all the statutory references will be emailed to you after the session. Just a reminder before we move on to questions of our next session, which will be here, as Rebecca said, in our new premises, Wednesday the 13th at 5 p.m. And that will cover how you prove disability in practice. So things like who bears burden of proof, witness statements, what should those cover, medical evidence, GP records, and experts in appropriate cases. So please do come along to that if you can. But let's take some questions now, if we've got a bit of time. I think we've had 2 in so far.
I think so.
So the first one is going back to this point about likely in the 12-month test. Does that mean more likely than not, i.e. 50%? Over to you, Rebecca.
So this could well
Yes.
point. So no, it's not a 50% test. I think if anything we would say it was perhaps a bit less than that.
Okay, so it's easier to meet that test than it having to show 50% likelihood of it.
Yes, so it's not a balance of probabilities test.
Okay. And we've got a second question. If you've been diagnosed with cancer, and we know that cancer is one of these deemed automatic disabilities as soon as you have a diagnosis. If you've been diagnosed but then given an all clear after 5 years, does your disability continue? Rebecca.
Now, that's a really interesting question, and it is one I have actually had in a case. There is, well, last time I looked, there was not any specific case law answering that question exactly, but the general view was, and certainly the view of my tribunal, was that yes, you would still be covered, you would still be disabled. And the short answer, or the easiest answer, is that even if it wasn't a current disability, it would be a past disability. So you would still have that protection. You've given the example there of the 5 years all clear, because traditionally I think we look at the sort of 5-year survival rates in cancer. But you could see the difficulties that if you say that once you've had the all clear, you're no longer currently disabled, that where do you draw that line in terms of the period of being all clear? But the short answer would always be that you would plead it as a current or past disability.
Okay, so you rely on it as a past disability as the alternative argument.
Indeed.
I see. Let's see, any other questions? Just a reminder that the in-person session won't be recorded next time. This one is being recorded, so you can watch it back, but the in-person one won't be, so you'll need to come along to that. Got a third question. Is medical evidence required to determine whether the factors are met? I suppose this is more for the next session, but perhaps give a brief view on that, Rebecca. I don't think it's always needed.
Not always needed, and sometimes it's not even that helpful. You will be expected usually to give disclosure of medical records as part of this thing, but it's not as common as you might think to have expert evidence. And I find increasingly in the areas such as depression and mental health, the tribunal will focus, or the court in your case will focus much more on what we call an impact statement, which is usually the evidence in the form of a witness statement of the person who says they're disabled, where they give evidence as to those impacts on their day-to-day activities, and that's the really important thing. It's probably because quite often the fact of the impairment is not really in dispute. It's really whether it meets those other limbs of the test.
Yeah, that's been my experience in employment and housing as well, that there's some cases where it's very tricky and you need a medical expert, but most of the time, certainly, it's really down to the person themselves to, as you say, explain in their own way the effect on their day-to-day activities. We've got some more questions coming in. How does the test of the impact on the ability to carry out day-to-day activities, how is it affected by the decision to retain EU law, and that day-to-day activities include work activities? Now, I might have to defer to you on this, Rebecca, as to the impact of EU law on this area. I mean, I know with what you mentioned with work activities that specialised skills don't normally count as a day-to-day activity. So a specialised work activity might not meet that definition. Do we know anything about how EU law might affect that, or whether Brexit affects it?
Not much at the moment. Obviously, the Equality Act is although we derive these discrimination principles from European law, they're obviously contained in an English statute, and the case law, although may have had reference to European cases, is still of benefit. And in fact, I would say disability is an area of the protected characteristics where we rely less on European cases than we do, for example, sex discrimination cases and things like equal pay, etc. And they all have a very strong grounding in European jurisprudence, whereas disability not so much.
Or homegrown.
Yes.
Anyway. Yes. So one area at least where you don't have to worry so much about Brexit and the impact. Less a topic question, but very happy to answer it. Do we accept instructions under legal aid for housing possession and ASB cases involving Equality Act issues? I'm happy to say we do. We have a full housing team here who are very happy to take instructions in this area, and we benefit with the crossover of expertise from our colleagues such as Rebecca in the employment team as well. Okay, I think that looks like the last of the questions that I've had come in. So all that remains is to say thank you very much to everyone who's attended, for joining and for your questions. And for we hope to see you, as I say, on the 13th of December in person for the next of our sessions, and we're hoping that there will be further sessions to follow in the new year, so look out for details of those as well.